This explainer is based on the works of Professor Kiskinov, and it tackles a question that really gets to the heart of our modern digital society. How do we define a legal act when technology is changing everything?
Just think about it for a second. Our legal system, the whole thing, was built for a world of paper, of physical documents, of handwritten signatures. But what happens when a legal decision isn't a piece of paper you can hold, but just an entry in a database? Or a rule that's buried deep inside a piece of software? This is the massive challenge that our information society poses to the very foundations of law.
So, to get our heads around this, here's the roadmap for our discussion. We'll start with the law's digital dilemma. Then we'll quickly go over the classic view of law. After that, we'll see exactly where that traditional understanding starts to crumble, introduce a new systemic way of thinking, and find the common thread that ties it all together, before we look ahead to the future of law.
Okay, so the main problem here is that our society is just evolving way faster than our traditional legal theories can handle. We're seeing all these new legal phenomena pop up that just don't fit into the old boxes we've always used.
You see, the crazy pace of technological and social change over the last few decades is basically forcing legal science to play catch-up. What we've always understood as a legal act suddenly feels like a pretty outdated definition because, well, it doesn't really cover things like automated legal decisions or rules that only exist in lines of code. To really grasp how big of a disruption this is, we first need to be super clear on the classical, foundational idea of what a legal act is supposed to be.
First up, we've got the normative legal act. Now this is the big stuff. Think laws, regulations, even constitutions. They lay down general rules that apply to everybody or at least to a big, undefined group of people, and they're meant to be applied over and over again.
And then on the other side, you have the individual legal act. This is more personal. Think of a contract between two specific people, a court ruling in one particular case, or a permit given to a named company. These are direct, one-off acts that create rights or responsibilities for specific parties. Sounds simple enough, right? But there's a bit of a historical blind spot.
And here's where Professor Kiskinov points out something crucial. For centuries, legal theory was almost entirely focused on applying the law that already existed. It didn't spend much time on the theory of how law is actually made. And that oversight has left the entire field a bit unprepared for the totally new ways of making rules that we're seeing in the digital age.
So this is where that classic view really starts to run into trouble. What on earth happens when these legal acts, which were born on paper, get translated into the virtual world?
We're shifting from things like spoken agreements and words on physical paper to electronic forms, records in a database, and even technical data formats. The very essence of a legal act is changing from something you can touch and hold to something that's just pure information.
Let's just walk through how this happens. An official makes a legal decision, let's say to register a new company, but instead of printing out a certificate and signing it, they just create a new entry in the digital commercial register. The act itself now exists only as data, and that leads to the million-dollar question. Does this still count as a valid legal act if there's no traditional document to point to?
And that really brings us to the core of the problem. If an algorithm automatically approves or denies your loan application based on rules that are just written into its programming, is that decision a legal act? Our old definitions, which are all tied to human intention and written documents, just start to fall apart. So how in the world do we fix this? Well, Professor Kiskinov suggests we need a fundamental shift in how we look at the problem. Instead of getting bogged down by the physical form of an act, we need to see it as just one part of a much larger, dynamic system. This is the big conceptual leap we all have to make. The law isn't just a dusty collection of books on a shelf. It's an active, functioning system. It's a process. And in that context, it doesn't really matter if an instruction is written on old parchment or in modern Python code. It's still part of this larger legal system in action. To build this new way of thinking, we use three main tools. First, there's legal systemic research, which just means we look at any act not by itself, but as part of the entire legal system. Second, we focus on legal expressions of will. That's the basic intention behind any act. You can think of it as its DNA. And third, we identify the legal constructions. These are the underlying blueprints or structures that organize our legal rules, kind of like the architectural plans for a building. So, by using this new systemic approach, we can finally build a unified theory that makes sense of everything, both the old legal acts and the new ones. We can find the common principles that connect a handwritten contract from the 1800s to an automated decision made by an AI today. And what this unified view shows us is that all legal acts, no matter what they look like, share some common qualities. They're all expressions of will, they all have some kind of structure, and they all fit into a larger system. Where they differ is in their application, their scope, who they're addressed to, what their function is, and this is the really critical part for our modern world. How they are formed, whether by a human or by an automated process.
So, what does this all mean? What's the big takeaway from this new systemic way of looking at things? We've seen the problem, we've looked at the traditional view, so let's wrap it all up.
If there's one thing to take away from all this, it's this. In our information society, we can no longer tie the idea of a legal act to a physical document. We have to learn to look past the form, whether it's paper or code, and instead see the function, the expression of will, and its place within the entire legal system.
As Professor Kiskinov concludes, the new legal realities of our time really do demand a new way of thinking. We are creating a necessary and, frankly, a profound break from legal theories that were built for a world that just doesn't exist anymore.
And that leaves us with a huge question for the future. As more and more of our legal world becomes automated and virtual, how do we make absolutely sure that core principles like fairness, transparency, and accountability, the very foundations of the rule of law, are not only preserved, but maybe even strengthened? That is the challenge that lies ahead for all of us.